This podcast is brought to you by Customplan Financial Advisors Inc, an independent insurance managing general agency in Canada. FINANCIALPODCAST.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Welcome, everyone, to today's podcast. Joining me today is Murray Harris from Resolute Law Group. Murray is a Calgary lawyer who practices employment, injury, and commercial litigation. Today we'll be talking about employment law in Canada. Quick disclosure, we're not here today to give specific legal advice, but to provide general information to the public. Murray, welcome, and thank you for joining us today.
Well, thanks, Stefan. Just a bit of background about me. I practice law in Calgary. I'm from here. Previously, I practiced in British Columbia and the Cayman Islands as well. I am the principal of Resolute Law Group. My clients are mostly in the Alberta area, but I do practice law throughout Canada and work for clients around the world.
Well, again, thanks for joining us, and I guess we should get right to it. When do I need an employment contract?
If you employ people for a longer period of time, or if they are going to work for you on a commission basis, or if you have assets to protect like client lists or patents or special procedures that you use in your business, you may want to have an employment contract with your employees. If you intend to enter into a fixed-term contract for a specific project, for example, you should consider putting that down in writing as well. If you're just hiring people on a casual basis, or it's something fairly simple like hiring restaurant servers part-time, you probably don't need an employment contract.
Excellent. So who should use one?
Well, if you run a business of any size, you should seek advice about whether you need an employment contract. If you're hiring workers to do work around your home, to do renovations, or for very short-term tasks like a single week or a day, you probably don't need an employment contract. But in many of those areas, such as having a nanny do work for you, or having contractors around your home, those relationships are governed by other types of legislation or other legal practices and customs. So people doing work on your house may not want or need an employment contract, but you should definitely talk to a construction lawyer about what the legal requirements are.
That's interesting. So how would you distinguish between a contractor and an employee?
Well, there are a lot of legal tests, and this is definitely an area in which a business should seek proper legal advice. If an employer characterizes a worker as a contractor, for example, but the first person fits within certain legal tests as an employee, the employer could be liable for fines and penalties to Canada Revenue Agency. They may even have to pay statutory withholdings. Not only that, but the worker is typically also tagged with a higher exposure for taxes, so no one in that relationship will be happy. I should stress that this area is extremely fact-specific. There are very few hard and fast rules to go over, and each situation is not the same. Generally, a small business can get some advice from a lawyer when they set up, and so long as the character of the work arrangements doesn't change, the advice should stay the same. If a particular one-off situation occurs, an employer should go back and determine whether that person is going to be a contractor or an employer. So that said, if you're employing a person and no one else is, they are probably an employee. If they have other contracts or they get income from other people, they may not be an employee.
It's very interesting. And how much would it cost to get one of these done?
Well, it's tough to say. How much is a car? So lawyers who specialize in small business law often have a package of general information And they might tailor a fee for a small business as an introductory amount for $500 or $1,000 if they get some other business from the person. However, a custom contract for an employee with a lot of unique terms may cost up to $5,000. Larger businesses will often have to spend a lot more on that, especially if the prospective employee also needs counsel to review it for them. Ultimately, you get what you pay for. So seeking out someone who's familiar with the process does help.
And I'm guessing that, a smaller business would definitely be paying less than a larger operation, right? And as you described.
That depends. If your business hires 2 or 3 employees and the relationships are going to be very, very long term and the terms are going to be few, you might be in for a smaller bill from your lawyer. If you have a large turnover in employees, if your employees have complex relationships or they do things that are very complex, or if you have a lot of assets, you might need more terms to be put in there. And that will definitely be something that requires more time for you and the lawyer to work together.
That's a good point.
You are listening to FINANCIALPODCAST.ca.
So what happens if there are no contracts and a dispute arises?
Well, that's a good question too. If an employee has a dispute and there's no contract, the issues in the dispute are governed by common law. If a contractor has a dispute with someone, it might be governed by other legislation depending on the industry that is being involved. Those principles of common law are fairly well defined, and a good employment lawyer can advise both employees and employers on what their rights and obligations are. If there's a contract in place, then in many respects the dispute will be governed by that, but there are still some common law principles that will govern it. As well, employees and employers often have contracts that do not say what they think it says, so there might be additional provisions that apply. The bottom line is that if you are a worker and you get fired or laid off, you should seek legal advice on what your rights are before you sign anything or accept any money. If you're an employer and you want to fire someone or lay them off, it never hurts to seek some legal advice prior to doing so. Ultimately, the ramifications of letting people go improperly can be very expensive, so it's always a good idea to have a plan in advance.
I have a question for you regarding this. If you are ever in a position where you're meeting with HR, they come to you, they offer you a deal, do you by some right have the ability to say you don't have to sign right now? Do you have a certain amount of time where you can consider their offer or their dismissal?
Absolutely. So an employer at law puts an employee in a position where they're obviously going to be anxious and under stress if they announce to them without any warning that their employment is terminated. And so what the law has said is that it's improper for an employer to stick a release in front of an employee with a check and say, you can have this check only if you sign this release. Generally, an employer has to give an employee an opportunity to seek out legal advice in order to determine whether the agreement that is being put in front of them is proper and meets with their legal rights.
Well, it's great that there is such protection for people out there.
It is.
So what happens if a worker is hired as a contractor and there's a dispute down the road on the status of the worker?
That's a good question. So at the end of the day, whatever's happened in the past can't be changed now. The facts that determine whether a person was a contractor or an employee are not things you can change after the fact. So an employer and a person who's a contractor, for example, could decide that going forward, the contractor will be an employee. They could decide that going forward, an employee will become a contractor. But it isn't something that's artificial. It has to fit within real legal tests that Canada Revenue Agency will accept. If they artificially create it, then ultimately they're going to be responsible, both of them. A contractor who was actually an employee is going to be responsible for probably a disallowed set of expenses and deductions, and so that will increase their taxes. Mm-hmm. An employer who unfairly characterized a contractor as that when they should have been an employee will probably get fined for failing to withhold taxes and other deductions, and they will probably have to pay those taxes and deductions first.
So at the end, they're both responsible.
At the end of the day, Canada Revenue Agency and other government entities will always go after both the employee and the employer if the relationship has been artificially contrived to be something other than it was.
Very interesting. Let's talk a little bit about online resources, because I think we're all doing this more and more now. We're Googling certain things and we're trying to find out if we can find a certain contract online. Do you like that? Do you like that concept where everyone just goes on and downloads something and just fills in the blank?
Well, in one sense, I love online legal resources because at heart I am a litigation lawyer. That's most of my work. So a lot of my work from people comes in the door because people have used contracts or precedents that they find on the internet. On the other hand, if your goal as a contractor, an employer, or an employee is to have well-defined arrangements where there's no surprises about people's rights and obligations, the internet's full of traps. Using precedents will put you in the situation where you might be using documents from other jurisdictions for another industry or from a source that's very old. So these are just a few of the pitfalls that I see all the time. And more importantly, whatever the document and its uses, a person who's not a lawyer often takes the document out of context and uses it improperly. So, for example, I recently dealt with some individuals who had thought they had an employment contract. In fact, what they had created was a share purchase contract where one person was going to buy into a company that they were supposed to be working for. So fortunately, no money was ever paid for the shares, so the shares themselves weren't actually bought or sold, but both the employer and the employee had no idea what their agreement said. They had no idea what they were doing, and at the end of the day, it cost them both a lot of money and a lot of time to sort it out, on top of the fact that they spent a lot of time trying to come to an agreement in the first place.
I can see, as someone who's constantly working with individuals on this, why you would love the opportunity to go after things like that. How do you go about choosing a lawyer for employment matters?
Well, employment lawyers are often divided down the middle into either pure employment lawyers or labor lawyers. The first kind deal with traditional employer-employee or employer-contractor issues, so the relationships between workers and businesses. The labor lawyers, typically deal with union issues. So if your needs are for non-unionized issues, then you should seek out a person who's an employment lawyer, as well as many lawyers who draft documents, and there are lawyers who go to court. So I am a litigation lawyer, and that's what I do. I assist people in disputes, how to avoid them, and how to get themselves out of them. But in employment law, there's a lot of crossover. There are a lot of capable solicitors who do employment litigation, and there are a lot of capable litigators who know their way around the employment business problems and can draft good documents for you. In addition to that, if you're in a small business and you're looking for a one-stop shop, there are a lot of lawyers out there who can assist you not only with things like incorporations and your lease review, but it can also provide you with rudimentary contract documents for basic employment relationships. Ultimately, if you've got a dispute because you've been laid off or fired, or you're about to lay someone off or dismiss someone, you should probably seek the advice of a lawyer who practices specifically in the area of employment law, and you'll probably want to ask them about their litigation experience.
Perfect.
You are listening to
FINANCIALPODCAST.ca.
So you're a worker and have been offered a job with a written contract. Should you seek advice from a lawyer?
I think you should. I don't want to sound like a hammer looking around for nails, but you are about to enter into a relationship that hopefully will be fulfilling and long-lasting for you. You're also going to spend a good chunk of your day on it. So if you're going to be agreeing to some terms and someone has handed you those terms in a contract, it's probably a good idea to know what it means.
Now, if I put my business owner hat on, and as an employer, should you suggest to that worker to seek legal advice as well?
You probably should recommend to your employees, if you're going to present them with a written agreement, that they go and seek some legal advice. There are pros and cons of this. First of all, the prospective employee might say that they want you to pay for it. If you're hiring a lot of people, that might be an additional expense for you. The other side of it is, if you are dealing with people that have had a relationship for a long time and you're merely modifying a couple of terms in the agreement, it may not be necessary. Bottom line, however, is as an employer, it doesn't hurt you if you recommend to your employees they seek legal advice. It does hurt you if you tell them they can't go get it.
Okay. In an employment law situation, does it make sense to hire a lawyer from outside the province?
It can. I have clients in British Columbia and in Ontario who use my services because their industry is here and their head office is somewhere else. Likewise, I act for people who work for the Alberta office of a British Columbia or an Ontario or a Minnesota company. So it's very worthwhile to use somebody from an employer perspective if you're confident that your counsel represents your interests and can do the job for you. If you're an employee and you work in Alberta and you've been laid off from an Alberta company, it probably doesn't make much sense to hire a lawyer in British Columbia unless for some reason your jurisdiction in the agreement requires that.
Perfect. Any advice for new and or existing business people?
Well, successful business people that I know historically have said that at the beginning they found a good accountant and they found a good lawyer and they listened to what they had to say. I think that is the basics. If you plan on hiring a lot of people, or if the job you've posted is complex, or if it's going to be long-term, or if there's risks involved for your business, like the loss of clientele or the loss of patents or special processes, you should definitely seek advice before you hire people. Having clear expectations in an employment agreement or a contract for services in advance will always save you a lot of headache.
One final question for you. What happens when someone in Canada works for a company that's located out of the country? Like their head office would be in Europe or something like that.
I've looked at that issue very recently. So if you live in Alberta and you're working for the most part in Alberta, but your employer is somebody from one of the United States or is from a different country, you might find that you're presented with a written agreement that requires you to turn to the jurisdiction of a particular state, or perhaps even to bring any dispute you have about your employment to a particular county court somewhere in Texas or something like that. The general rule is if you reside in Alberta and you're carrying on work in Alberta, generally your work's going to be governed by the laws of Alberta. So a lot of foreign firms will try and impose their foreign laws upon people that live in British Columbia or people that live in Manitoba. But, again, a general principle, it's probably not going to work. If you live in British Columbia, your employment is going to be governed by British Columbia. Now, there are a couple of caveats on that. If you're a person who resides in Manitoba, but you regularly travel over the border and perform sales work in North Dakota, or if you are traveling through Central America as part of your work, there are going to be a lot of complex issues about where the law is that pertains to your employment, just as there would be laws pertaining to where you have to pay taxes. So those are situations that you definitely want to look into, regardless of whether you're an employer or an employee or a contractor.
Does it matter where the dispute arises?
It does.
Yeah.
Absolutely. This is an area that we as lawyers call the conflict of laws, and it's decidedly complex. There are people that write some very large textbooks and update them quite regularly as part of their living. There's also people that practice very specifically in that area. So if you reside in Ontario, work in North Dakota for an employer from Abu Dhabi, and they've imposed upon you the laws of England and Wales, you should probably go and seek legal counsel about what has to happen at every phase of your employment. And if there's a dispute, you definitely want to seek some very specialized counsel.
You are listening to FINANCIALPODCAST.ca.
Well, I really want to thank you, Murray, for spending this time with us today. I'm sure there might be quite a few questions as a result of this. Are you willing to share with us how to get a hold of you if anyone has any questions or if they're looking for legal advice?
Sure. By the time this is heard, there will be a website, which is www.resolutelawgroup.ca, and my contact information is on there. I answer the phone.
Perfect. And I have to tease you a little bit. You are a lawyer, and I know that you have a disclaimer for us, so please go ahead.
Okay. Thanks, Stefan. In closing, this interview and the information in it is not legal advice. You should not construe this as necessarily applicable to your situation, nor is anything I've discussed to be considered as applicable outside Canada. Very likely, your needs will be vastly different than what's been contemplated here, and any legal issues that you have should be referred to appropriate legal counsel in your jurisdiction.
Perfect. Thank you very much once again.
You're welcome.
The views expressed here are those of the participants and not those of Customplan Financial Advisors Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.